Every day we see more government investigations, more people being brought into the criminal justice system. And that's why our team at Prison Professors works so hard to try and share as much information as we can. And fortunately, we have a lot of people on our team. One of them includes Larry Hartman, also known as his formal name, Lawrence Hartman, who wrote this article today on analyzing your legal exposure. Because Larry doesn't have access to all the technology that I have, I am taking the liberty of creating the YouTube version of his article and also the podcast. But we encourage you to visit us at prisonprofessors.com. Go to our blog section at the top of the page, and you will see all types of articles that will help you along the journey. And you should be working to understand this system so that you don't face the types of difficult sanctions that can really obliterate your prospects for peace and prosperity. A person always wants to be working toward a better outcome, and that means you've got to start by analyzing your legal exposure, which is the topic of today's blog and podcast. So this, again, is written by our colleague Lawrence Hartman. I'm going to just start reading from his article right here. So you have either been indicted or you're in fear of an indictment. The prospect is terrifying. I've edited this. Let me go to the edited version. Yes, here's the edited version. I just edited this morning. If you are in fear of an indictment, or if a grand jury has returned an indictment against you, consider the legal exposure. What are you facing? The prospect is terrifying. Even just a short stint in prison can feel like the end of the world. That's understandable. Many people feel a strong desire to proclaim innocence and put the whole chapter behind them. Certainly, I know a lot about that. I got arrested. I was charged with a serious crime back in 1987, and I just didn't want to believe that I could potentially really be facing a sanction that could put me in prison for multiple decades. But ignorance of the law does not excuse you from the harsh ramifications of breaking the law, and that's why Larry's article is so valid for people. Beating the feds, as Larry writes, is a daunting task. Most people are better served by trying to minimize the damage. After all, there's a huge difference between a long and a short sentence, both personally and professionally. And to that end, it is critical to understand exactly how the process works and how to best navigate the system to get the best possible outcome for you. And there are two things that impact how much time you are looking at. One of them, of course, is going to be the statute that prosecutors brought against you. The second is going to be how you're going to score with the sentencing guidelines. A charge is something like possession of drugs, distribution of some type of illicit act, money laundering, wire fraud, mail fraud, conspiracy to commit any of these acts. Those are basic statutes that can result in serious problems for an individual. Each specific charge carries a maximum sentence for a specific number of years. And that all depends on the statute that Congress authorized and that the president signed with his pen that turns a bill into a law. But the penalties associated with breaking the laws can span anywhere from probation to life in prison. And the charges, prosecutors can stack the charges, meaning they it can be the same activity, but prosecutors can make those charges go one on top of the other, or a judge can impose the sentence one on top of the other. As an example, you can think of the movie star Wesley Snipes. Was it Wesley Snipes? I think it was the guy that did Blade Runner. I think it's Wesley Snipes. Was one of these people that believed that the United States government didn't have the authority to bring charges or collect tax. And so he was a tax protester. Well, authorities brought criminal charges against him. I don't know whether it was through a trial or whether through a plea, but he was convicted of 3 misdemeanors. Now, the difference between a misdemeanor and a felony is that a misdemeanor has a maximum statutory penalty of 1 year or less. A felony is a crime that Congress has authorized a penalty of longer than 1 year. So if it's a year and a day, it's a felony. If it's less than a year, it's considered a misdemeanor. But in Wesley Snipes' case, what the judge did is he sentenced him to 1 year, which is the statutory max for each count, but he ran them consecutively. So he stacked the sentences. So instead of getting a 1-year sentence, he got a 3-year sentence, which is a big deal. So a single activity can result in a very long sentence if a judge stacks the charges. So general guidelines govern how the prosecutor should charge, but generally the U.S. attorney has a lot of discretion. And here Larry talks about his case, and I'll read from that paragraph. In my case, just to give you an idea, prosecutors brought 35 separate charges. A different AUSA prosecuting a different person in a different jurisdiction may have faced only 1 or 2 counts. The number of charges can be unbelievably terrifying, especially when a person doesn't understand the workings of the system. Theoretically, the charges that Larry faced carried a potential penalty in excess of 300 years. That's what he would have faced if the judge stacked those cases. But generally, judges will run sentences concurrently at the same time instead of consecutively. So that's one of the reasons that the U.S. attorney might consider dropping specific charges in exchange or during a plea negotiation. If the person pleads guilty, the prosecutor might drop 30 counts and just say, I'll just take the 1, but it's going to carry 10 years. A prosecutor only needs a single conviction to secure an extensive prison term. And in Larry's case, he argued for a plea agreement that resulted in a 10-year sentence. Now, you also have to understand the sentencing guidelines. That's the second part of a legal analysis. A person should really understand the guidelines to understand legal exposure. In Larry's view, the guidelines reflect a strict and onerous standard birthed during the Law and Order 1980s. Guidelines removed discretion from sentencing judges, creating hard and fast rules. In the beginning, the guidelines tied a judge's hands with mandatory sentencing ranges. At the turn of the century, when it went from 1990s to 2000, the Supreme Court started to make a series of rulings that removed the mandatory nature of the guidelines, making them advisory. For more insight on the sentencing guidelines, you might click the link that I have on the website. It's called Basics of Federal Sentencing Guidelines, because in that lengthy article, I provide a lot of historical context. And when I went to prison before there were federal sentencing guidelines in 1987, and I was in prison when the guidelines became the way of the judicial system. So I know how they were rolled out. And in the beginning, the reason for the guidelines is that judges across the country were giving different sentences for similar behavior and with similarly situated people. There was a system called a parole system in place back then. That means that you had determinate sentencing and indeterminate sentencing. Indeterminate sentencing is what we had before the guidelines, meaning a judge would impose a sentence, then the person would go before a parole board, and a parole board would assess whether that person should remain in prison or maybe that no longer imprisonment is warranted. With a determinate sentence, which is what the guidelines introduced, a judge imposes a sentence based upon the statute and what the U.S. Sentencing Commission determines is the appropriate length of time, and that person is going to serve 85% of that time. A lot has changed since the introduction of the guidelines back in 1987. There has been Supreme Court rulings that have removed the mandatory nature of guidelines and made them advisory. But in addition, there has been reform acts like the First Step Act and the Second Chance Act that really empowers a person to advocate for himself and can really have a meaningful impact on how much time a person really serves. So let's go on with what Larry was writing. And so in order to get that, I'd encourage you to read the more extensive article that really focuses on the guidelines. With the sentencing guidelines, the federal prison population really bloated, and it grew by tenfold. When I went to prison in 1987, the federal system incarcerated about 30,000 people. I don't know if it's tenfold, because now we incarcerate about 200,000 people, or that's really where we peaked out at. I think it's even less now. But it has grown a lot. Prison system has changed a lot. And it's important to understand that so that you can advocate for yourself in the most appropriate way. With the guidelines, the system considers the nature of the crime and also the history of the person convicted. Guidelines provide a scoring mechanism for each segment on a vertical and a horizontal scale, and the intersection of those two scales is where the guideline range is, and it's going to be a range of months. And typically, a judge is going to use those months as a starting point, then various factors brought about by your attorney, but more importantly by what you do or a person charged with a crime does, is going to influence what happens. A person can always work to advocate for a lower sentence. And for this reason, we encourage people to learn as much as possible about how the system works, about the stakeholders in the system, and about sentencing. The more a person understands, the better a person can work towards self-advocacy. A person should learn more about the ways that other people went through the system and how people work to get a favorable outcome. So that's really what we offer at Prison Professors, and I would encourage people to visit our site. Make sure that you go to our blog so that you can get all kinds of information with regard to how to position yourself for the best possible outcome. And you can get free stuff there. Like if you download, I would encourage you to download a free copy of Earning Freedom. You can listen to it as an audio version, or you can download the digital version, or you could buy the soft cover copy from Amazon. And I've got links to it right on the page. But we've got a lot of information. I'm thankful to Larry and Kayla and other members, Justin and other members of our team, Mike, who do work so hard to try and share information that will help people get the best possible outcome. That's what our team does at Prison Professors. We would love it if you would subscribe to us on YouTube or on our podcast, or just sign up for our newsletter so that you can stay in tune with what are the best possible outcomes for people experiencing the criminal justice system. I am Michael Santos, and on behalf of our entire team at Prison Professors, really want to thank you for listening and absorbing the work that we produce. Thanks.